Let's go on the record in the case of the state versus Crystal Hairston, case 21 CF 1891. Appearances, please.
It appears by ADA Colleen Lennon.
Ms. Hairston appears personally in custody with attorney Catherine Dorrell. We did receive a copy of the criminal complaint and waive its reading.
All right, thank you. And I think, Ms. Dorrell, when we tried to start earlier, you confirmed that the address is the best one?
Yes.
Very good. And Ms. Lennon, the state's position on bail?
The state's requesting high cash bail in the amount of $1.5 million. If cash is posted, the state's requesting referral to pretrial services with GPS monitoring. Additional conditions that the defendant is not to leave Dane County, Wisconsin, that the defendant be banned from Braxton Place on West Washington, that the defendant is not to possess any dangerous weapons, that the defendant is not to possess or consume any alcohol or be on the premises where it is primarily served or sold as its primary business. Argument for high cash bail. High cash bail is necessary here. On a far lesser case in 16 CF 2221, the defendant failed to appear on December 20th, 2016 while out on a signature bond. The defendant is facing the highest crime Wisconsin law has. While setting bond, the court is to consider possible penalties and also the strength of the state's case. Here, not only did the defendant admit the crime, but it was caught on surveillance video from start to finish. You can observe the defendant exit the elevator, the defendant get up from the bench and attack the unsuspecting victim, causing his death. Through the video, you maintain complete visual contact with the defendant and decedent. In the video, you observe the decedent exit the elevator. Throughout the video, you maintain visual contact with both parties through those moments and until law enforcement arrests the defendant. There is no stronger factual case given the strength of the state's case, the exposure, and some history of failure to appear on a signature bond. The state believes that high cash bail and the amount requested and the non-monetary conditions are appropriate here and asks that the court adopt them.
Thank you, Ms. Lennon. And Ms. Dorrell?
Your Honor, no objection to the non-monetary conditions requested. Ms. Hairston is indigent. Her only income is SSDI. She has no ability to post bail whatsoever, and we do oppose the imposition of cash bail in this case.
All right, thank you. I have reviewed the allegations in the criminal complaint. Without belaboring it, Ms. Lennon accurately describes those allegations are that Ms. Hairston engaged in murdering somebody through multiple stab wounds to the heart. It's also alleged that this is captured entirely on videotape, suggesting that the state has an extraordinarily strong case, at least as to the guilt question. I suspect there may be other issues that will be raised at some point in the future, but that's for another day. In terms of likelihood of appearance in court, she faces the possibility of life in prison without the possibility of parole. If she were to be convicted of this charge and the court remains silent on the issue of eligibility, there'd still be the majority of the remainder of her natural life likely as a period of incarceration. It creates a pretty big incentive to flee. And I think the state's position that a substantial cash bail is necessary is warranted. I don't know that there's a lot of practical difference between these numbers, but I think that a bail at $1 million is both necessary and sufficient to assure her appearance in court. I think that's more in line with what I typically see in other cases that are similar in nature, recognizing that no two cases are the same. I'll order as conditions that if she posts the bond, she report to pretrial services, that she contact them immediately upon posting. They'll outfit her with the GPS, and the other conditions that have been requested are adopted. Should we schedule a preliminary hearing within the next 10 days, Ms. Dorrell?
Actually, Your Honor, at this time, I would request a competency evaluation be ordered.
Okay, and Ms. Lennon, any position on that?
No position.
All right. Given the information described in the criminal complaint, the representation of counsel, I think that there is reason to doubt competence to proceed. This is one of those issues that counsel has a requirement to raise on a prompt basis. If she suspects it's an issue, she's done that. That's appropriate, and it's just fair that we get that issue addressed sooner rather than later. So I will direct that a competency evaluation be conducted. That means we won't be scheduling a preliminary hearing now, but we'll instead schedule a competency hearing within the statutory timeframe. Take care, everybody. I hope things get as good as they can under the circumstances.